This matter is State of Ohio versus Jordan Williams. Each party will have 15 minutes to present oral argument. The appellant proceeds first and may reserve up to 5 minutes for rebuttal. So if you wish to have reserve any time for rebuttal, please let me know and I'm keeping time. And if you would, just come up to the podium that's closest to us. We have read the briefs and we're ready to begin.
Thank you, Your Honors, and I would request a 5-minute rebuttal.
Yes.
Your Honors, my name is Attorney Denise Wellens, and I represent the appellant in this matter, Jordan Williams. Jordan Williams was charged with a murder charge. The main reason why we're here today is that the appellant argues that the that the trial court erred in allowing the jury to allowing the felony murder charge to reach the jury because when the trial was had at the end of the state's case, the trial court ended up granting a Rule 29 on count 3. That was a felonious assault charge, which was the predicate offense to the felony murder charge in count 2. In fact, prior to the start of the trial, prior to voir dire rather, the state of Ohio had stated to the court on the record that the charge of the felonious assault, the count 3, was actually the predicate offense to the felony murder, and that's why they were charging it. So after the state rested, the trial court granted the defendant's motion for Rule 29, which was this felonious assault charge, i.e. the predicate offense for the felony murder case, or felony murder charge rather.
Was the criminal Rule 29 motion filed in writing, or was this a verbal motion?
Your Honors, it was on the record.
I understand
stated
that.
by the judge. He did not, at the time, reduce it to writing. There was an issue in regards to this case where the appeal was filed and the court had to go back and actually put an entry on stating that it had granted the Rule 29 motion because it had made the mistake and failed to reduce it to writing. So the trial court did in fact reduce it to writing, but it was after the trial had concluded.
Was it while the case was before us on appeal? Had the notice of appeal been filed?
The notice of appeal had been filed, and then we had gone back to the trial court because this court had said that it was not a final appealable order. We had gone back to the trial court, and the judge had realized, or somebody had realized, that it just wasn't reduced to writing. There were a few different defects. We had a visiting judge at the time, and there were a few different defects that were had. There was a couple of specifications that were also not reduced to writing that had to be fixed as well when we went back to the trial court. So all of this was
this
set
on a non-proton?
Yes.
Non-proton order?
Yes, it was.
Okay.
So, Your Honors, we argue the sufficiency of the evidence in this case, and that the trial court, once they entered this criminal Rule 29, or granted the Rule Criminal 29 motion in count 3, that the jury was barred from hearing the felony murder. The acquittal of the felonious assault charge operates as a matter of law and precludes the conviction of felony murder, which was the count 2, which he ultimately was convicted of. Now, what is extremely important to note in this case is that the inconsistency in the verdict. Now, there are several different cases, some that the state of Ohio may cite. However, in State versus Liberator, the victim here was charged with the defendant was charged with aggravated arson and aggravated murder, with the aggravated arson as the predicate offense. The jury acquitted the defendant of aggravated arson and hung on the aggravated murder charge, and the court found that since the aggravated arson was the predicate crime for the aggravated murder, the judgment of acquittal on the aggravated arson foreclosed retrial on the defendant on aggravated murder. So that case is very similar to the case that we have before us today. And basically here we have an inconsistency in the same count. The state may argue an inconsistency in verdicts, but we have an inconsistency within the same count, and jeopardy would attach.
And how is it that there's an inconsistency within the account, within the same count? The count is murder with the predicate.
Yes, Your Honors. So under murder, RC 290302 states that no person shall cause the death of another as a proximate result of the offender's committing or attempting to commit an offense of violence that is a felony of the first or second degree. The offense of violence that the state relied on here was count 3, which was felonious assault. That charge was dismissed,
Right.
And so therefore the murder charge should have been instructed as a reckless homicide because there no longer was the predicate offense that was before the jury to consider as part of this murder charge. And so there's where we have the inconsistency.
Well, I understand your argument, and it's very logical. It's just reconciling it with the case law that seems to differentiate between inconsistencies among counts and inconsistencies within counts. What you just described, to my way of thinking, represents inconsistency, an inconsistency among the counts, among the felony murder count and the separate felonious assault count, which was dismissed, but not within the count of felony murder itself.
Well, I think you can have both in this case because you do have separate counts. You have the murder and the felonious assault, which are separate counts.
Mm-hmm.
However, when you just look at the murder charge, that's an inconsistency in the count itself because of the fact that there's no predicate offense.
But in order to get to that point, that there's no predicate offense, you have to look at, the reason why you can say there's no predicate offense is because the trial judge dismissed or granted the criminal rule 29 motion with respect to the other count.
Yes.
So that, okay, all right, I'm following.
Your Honors, United States versus Powell explained that an inconsistency in the verdict does not arise out of inconsistent responses to the different counts, but only arises out of inconsistent responses to the same count. And that's what we would continue to reiterate here, is that it is within the same count. So if we just were to focus on the murder charge, which I believe is the main argument here, that we are talking about one count. Also, Your Honors, the trial court erred when it failed to properly instruct the jury of the lesser included offense of reckless homicide. And again, the reason behind this is because the trial court had granted the Rule 29 motion, and therefore all of the elements could not possibly have been met for the murder since the predicate offense was done away with. So the trial court improperly instructed the jury as to this murder charge, and instead should have granted the reckless homicide instruction. The trial counsel in this case had requested the lesser included offense, which would have been a felony of the third degree, based on the evidence and all the different objections in the pleadings. Mr. Williams stated that the trial court raised an objection to the court's lack of instruction on the lesser included offense on count 2 of the indictment prior to the instructions being sent to the jury. And then here in Loudermill, where the evidence in a criminal case would support a finding by the jury of guilt of a lesser included offense for which the defendant was indicted and trial, the refusal of the trial court to charge upon the lesser included offense is prejudicial error. We would argue in this case that not only was there insufficiency of the evidence in regards to the murder charge, as we spoke about before, because there was no predicate offense to the compound offense, we would also argue that there was prejudicial error that had occurred because of the instruction going to the jury of the murder charge and not the reckless.
Let me stop you for just a moment. I couldn't recall whether you asked for 5 minutes. Please.
Yes.
5 minutes? You are there.
Thank you, Your Honor.
Thank you.
May it please the court, my name is Natasha Guerrero and I represent the County of the State of Ohio in this matter. To start out first with addressing the Liberator case cited in appellant's brief and argued here today, the state would submit that that is distinguishable from what we have here presently. In Liberator, there was a first indictment and a trial held, and during that trial, the aggravated arson count, the jury did find the defendant not guilty of that particular count. Then the defendant was indicted again with regard to an aggravated murder, and there the court determined that because the state would have to prove the aggravated arson, which had already been, he had already been found not guilty of, that in that case, the state could not go forward on the aggravated murder because it was required to show something that had already been addressed by a jury. Here, we're dealing with somewhat of a more unique situation in that the defense requested that the felonious assault charge be dismissed. Although the trial court granted, the trial court never made an actual determination that there was insufficient evidence as to the felonious assault charge.
Well, what would be any other statutory reason or reason under the rule for granting the Rule 29 motion?
Unfortunately, correct, that the actual Rule 29 addresses it being as insufficient, but it appears as though, from reading exactly what the trial court actually stated on the record, that it wasn't an issue of insufficiency, but rather to consolidate it for ease and less confusion of the jury.
Oh, and to that point, I read that in your brief, I thought that was curious. What's the procedural vehicle for the court doing it?
In doing, the trial court can make any sort of amendments to indictments through Criminal Rule 7D throughout the process of the trial prior to, during the trial.
Well, the trial court, it sounds as if the trial court didn't say it was amending the indictment.
No, I couldn't make the, no, the trial court didn't state that explicitly, that he was making an amendment to the indictment pursuant to Criminal Rule 7. Although his reasoning as to why he granted the Rule 29 motion appeared to have been in that vein of amending it for ease of the jury.
So you have the murder charge.
Correct, Your Honor.
The state has said that the predicate is the felonious assault.
Correct, Your Honor.
The court grants the Criminal Rule 29 motion with
Correct.
regard to the felonious assault, but then instructs the jury so that there was no confusion as to the elements of felonious assault.
Correct, Your Honor.
Okay, that's problematic. At least you know, I'm just having trouble following that. How you get there.
With regard to how I guess, I'm not fully understanding, I guess, the question you're asking.
Well, it really wasn't a question, it was just.
Sorry about it.
That's okay, go ahead with your argument.
And as you pointed out, Judge Moore, the trial court did in fact instruct the jury as to all the elements of the felonious assault charge within that felony murder count. And the state did raise that with regard to the judge, you know, indicating that, yes, felonious assault was in fact the predicate that we're arguing with regard to the felony murder. You know, making the argument, yes, we have to make that argument to the jury. And in fact, the trial court did indicate, I am not foreclosing you from making that argument. You are able to make the argument with regard to the felonious assault as being the predicate for the felony murder. So, although maybe the vehicle with which the trial court used to get to that point, it does appear that he never made that finding of it being some sort of insufficient evidence as to why he was actually dismissing the felonious assault charge. And also to that point, the trial court never did reduce that decision to writing. And there is a case out of the 12th District, State versus Movis, in which the trial court there made a finding that dismissing the burglary of the second degree and actually instructed the jury as to a burglary of the third degree. However, never reduced that to writing, presented that to the jury, and in that particular case, the 12th District determined that because it wasn't reduced to writing, that was not a final appealable order, and because it had been presented to the jury in that particular circumstance, it was just an eliminating of one of the elements of the second degree burglary to bring it down to a third degree burglary. Therefore, the defense there was not foreclosed from preparing because it was all the same elements minus one that was actually presented to the jury at that time.
I thought I understood your opposing counsel to indicate that while the trial court did not initially reduce to writing its ruling on the motion, it did later in a non-proton order reduce that to writing. Did it do so with regard to the motion, the criminal rule 29 motion?
I know that the matter was initially filed, was appealed, and this court did indicate, you know, there is a charge here sitting that has not been addressed. And then from there it was remanded, and I believe at that point was reduced to writing. Unfortunately, I don't have the journal entry right in front of me as to what exactly the verbiage was with regard to that. And with regard to the second assignment of error, it appears that the appellant is making an argument that because the reckless homicide was instructed on with regard to the first count, that it also should have been provided with regard to the second count of felony murder. However, although yes, reckless homicide is a lesser included of felony murder, just because it's a lesser included charge does not automatically mean that an individual is required or is allowed to have that lesser included offense instruction unless there was evidence presented to both the acquittal on the charge as well as to a finding of guilt as to the lesser included. And here, the jury was presented with felonious assault as a part of that felony murder, did find beyond a reasonable doubt that the defendant was in fact guilty of that, and the evidence did support that finding. We had both of the co-defendants testify as to Mr. Williams shooting several times into the vehicle of the victim in this matter, as well as some testimony of a third witness who was with the defendant after the shooting, which indicated that he, during some conversations there, did admit to shooting once accidentally into the vehicle, but then shooting more than once also into the vehicle at that point. As such, just the reckless homicide jury instruction would not have been appropriate in this matter, despite the fact that it was presented to the jury with regard to the first count. There are two different mens reas that were required with regard to those two counts, so we had definitely had different evidence that would have been needed with regard to both of those counts. Therefore, the state would request that this honorable court overrule the assignments of error in this matter and uphold the decision and sentence that was issued by the trial court. Thank you.
Thank you. Counsel, you have 4.5 minutes remaining.
Thank you. Your Honor, the forensic evidence here in this case only shows that one shot was fired into the vehicle. Just that is listed in my statement of facts. Moving on from that, Your Honor, I do have the entry dated December 9, 2015, signed by Judge Thomas Corney, that states that the judgment entry of conviction and sentence filed by the court on July 20th, 2015 is amended to correct and to show that count 3, felonious assault, statute number F2 with 2 specifications, was dismissed by granting in open court and on the record as to count 3 only, defendant's motion for acquittal per Rule 29. All other portions remain original.
What's the date on that order?
December 9, 2015. And, Your Honors, it should be attached to the back of my brief.
Thank you.
Regardless of any verdict by the jury in this case, Your Honors, a prior determination by the trial court that the state of Ohio did not meet its burden of proof as a matter of law on the felonious assault charge resolved that issue against Mr. Williams and resolved furthermore the element of the felony murder charge in his favor, which would then prohibit the conviction despite the jury's verdict. This case fails to contain sufficient evidence to support the jury's finding that the defendant did in fact cause the death of another as a proximate result of committing or attempting to commit an offense of violence, i.e. the felonious assault charge of the first or second degree. The jury's verdict, Your Honors, must be set aside and reverse. We ask for a reversal in this matter.
If the court had in an open court, they instructed the jury that notwithstanding the dismissal of count 3, the predicate offense to the murder remained and obviated the confusion that the jury might have been under. Would that have made a difference? Or your argument is if once you fail to prove the separate felonious assault, you cannot ever use it again?
I think both arguments are appropriate here. One, that they should never have received the murder charge, and 2, they should have been instructed accordingly. Saying they should have been instructed and said and explained that the felonious assault charge was in fact dismissed, and therefore this is what you need to look at.
Well, where would the predicate offense be if that was dismissed?
Right, that's what I mean.
Right.
The trial court should have explained that.
So what you think the trial court should have done is dismissed everything. Once the felonious assault fails, then the murder as charged couldn't be supported.
Right, the trial court could in fact have done that.
But you say that the court then should have given the lesser included
Right.
instruction on
Or,
both.
right, since he did not dismiss it, then he should have advised the jury accordingly. of what the appropriate standard and of law should have been and what they should have been looking at.
Any other questions? Thank you. Thank you both for your presentations. The court will take the matter under advisement, will issue an opinion, which will be sent to both parties, and please do check the Supreme Court website as we post our decisions there.
Thank you.
Thank you. Have a good day.